courtroom's rigged, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof. Hey.
I forget. Before bringing the jurors in? No, Your Honor. On behalf of the defendant?
No, Your Honor.
Okay. Ladies and gentlemen in the gallery, okay, all trials are emotional. And trials such as this are even more so. You may see or hear things which you disagree with, which makes you upset, angry, or which you feel a need to respond. As difficult as that may be, okay, you can't do that in this courtroom. My concern is that you may do something that ultimately could influence one of the jurors. So that if you find yourself or see yourself getting emotional because of either something that's being said or something that you see, then you need to excuse yourself out of the courtroom. If I see someone doing something that I believe is in some way attempting to influence the jurors in some manner, okay, I will ask one of the deputies to have that person removed from the courtroom. One of the ways that we can ensure that both sides in this case have a fair trial is by making sure that there are no outside influences that in any way impair their ability first to be fair and impartial, but to be able to render a just verdict in this case. So I appreciate up to this point, at least all the folks that have been in the gallery have been very respectful for these proceedings. And I would hope that that would continue as we move throughout this trial. I've already previously indicated that unless the court has provided you permission to do so, okay, you cannot take photographs, you cannot take videos of these proceedings. If I find out that someone is sitting in here who has not received permission from the court doing so, I will have that person removed from the courtroom, and they will not be allowed to return. So thank you, ladies and gentlemen. All right, Mrs. Harper. Okay. Type something again. Okay, we're good. would remain standing. Everyone else may be seated. If you would please raise your right hand. Do you swear or affirm that you will diligently inquire into and carefully deliberate all matters between the state of Ohio and the defendant, Adam Coy? Do you swear or affirm you would do this to the best of your skill and understanding without bias or prejudice, so help you God, or this you do, as you shall answer under the pains and penalties of perjury? Please indicate by saying, I will.
I will.
You may be seated, ladies and gentlemen. All right, good morning, everyone.
Good morning.
All right, welcome to courtroom 4B. Okay, in a moment, we're going to have opening statements of counsel. Opening statements of counsel is information that will hopefully help you as you are listening to and considering the evidence. Opening statements are not evidence in this case. It's information that the attorneys anticipate, evidence that they anticipate you will see and hear throughout the trial. Before we start with opening statements of counsel, I do have some instructions that I'm going to read at this time. It's important, please, that you listen up while I do so. During the trial and after closing arguments of counsel, I will have a further opportunity to instruct you on matters of the law which you are to follow in this case. It is my duty to instruct you on the law, and it's your duty to follow the law as I will state it to you now, during the trial, and at the conclusion of the evidence. First of all, it is your exclusive duty to decide all questions of fact that are submitted to you. In connection with this duty, you must determine the effect and value of the evidence, and you must not be influenced in your decision by any sympathy, prejudice, or passion toward any party, witness, or attorney. If in these instructions, or the instructions which I will give you at a later point in time, any principle or idea is repeated or stated in varying ways, no emphasis is intended, and none must be inferred by you. Therefore, you must not single out any particular point or individual sentence or instruction and ignore the others. Rather, you are to consider all of the instructions as a whole and to consider each instruction in relation to all the others. The fact that I give you some of the instructions now and some at the conclusion of the evidence has no significance as to their relative importance, nor the order in which I give you the instructions have any significance. The attorneys for the parties will have very active roles in the conduct of the trial. They have conducted the voir dire. They will make opening statements. They will question witnesses, make objections, and finally, they will argue the case as their last step before you hear my final instructions and commence your deliberations. I want you to remember, however, that the attorneys are not witnesses, and since it is your duty to decide the case solely on the evidence which you see or hear in this case, you must not consider as evidence any statement of any attorney made during the trial. If a question is asked by one attorney and an objection to the question is made by another attorney, the duty is placed by law upon the court to decide whether the objection should be sustained or overruled. If the objection is sustained, you will then not hear the answer to the question, and you must not speculate as to what the answer might have been or for the reason for the objection. In addition, if I sustain an objection to a question, you are to disregard the unanswered question. If a question is asked and the answer to the question is given before an objection is made, and if I sustain that objection, I am instructing you now that you are to completely disregard the question and the answer you have heard, and not to consider any for any purposes whatsoever. I understand it is a difficult concept to disregard something that you have already heard, but it is an important concept for you to follow. If I overrule an objection, the witness will be permitted to answer the question, and you should not be concerned with the fact that an objection was made or as to the reason for my ruling. You are the judges of the facts, the credibility of the witnesses, and the weight of the evidence. To weigh the evidence, you must consider the credibility of the witnesses. You will use the test of truthfulness, which you use in your daily lives. These tests include the appearance of each witness upon the stand, his or her manner of testifying, the reasonableness of the testimony, the opportunity he or she had to see, hear, and know the things concerning which he or she testified, his or her accuracy of memory, frankness or lack of it, intelligence, interest, and bias, if any, together with all the facts and circumstances surrounding the testimony. Use these tests and assign to each witness's testimony such weight as you think proper. You're not required to believe the testimony of any witness simply because he or she was under oath. You may believe or disbelieve all or any part of the testimony of any witness. It is your duty to determine what testimony to believe and what testimony not to believe. One witness, if believed by you, is sufficient to prove any disputed fact. Circumstances in any case may arouse sympathy for one party or the other. Sympathy is a common human emotion, and the law does not expect you to be free from such normal reactions. Again, you must decide the case solely on the evidence and the law before you, and must not be influenced by any personal likes or dislikes, opinions, prejudice, sympathy, or biases, including unconscious bias. Unconscious biases are stereotypes, attitudes, or preferences that people may consciously reject, but may be expressed without conscious awareness, control, or intention. Like conscious bias, unconscious bias too can affect how we evaluate information and make decisions. But please understand, ladies and gentlemen, the law and your oath as jurors, which you have just taken, require you to disregard sympathy, to disregard, anything that you would use negatively in evaluating the evidence. When you return to the when you came to the courtroom today, because this is your first time here for many of you in 4B, you noticed that there were notepads in the seats. Okay, the notepads have been provided to you if you wish to take notes. Okay, you're under no obligation whatsoever to take notes. Some jurors take notes because they believe that doing so helps them to recall the testimony. Other jurors do not take notes because they believe that it distracts from their ability to listen to the evidence. Whether you decide to take notes or not is your own personal preference. Now, the notepads are the property of the court. What that means is that anytime that we take a break, just leave the notepads in the seats and we will collect them at the appropriate time. When you go back to deliberate, okay, you will have your notepads with you. But please just remember, just because one juror took notes and another juror did not, that does not mean that the juror who took notes' memory was any better than the juror who did not take notes. At the conclusion of your deliberations, we will once again collect the notepads, rip out the pages, and have them shredded. Also, you see Mrs. Manahan sitting here taking down everything that's being said in the courtroom. Now, I don't want you to think that as the testimony is going on, and by chance you happen to miss something, daydreaming or whatever the reason may be, that you think, okay, well, that's not a big deal. When we go back to deliberate, I'll just ask the court to have that portion of the testimony read back. It's in the rarest of circumstances that I would have any portion of the testimony read back. So it's extremely important that you listen to the testimony as it's being presented. As you recall, I had indicated to you previously that usually I like to go about an hour and a half or so, but it kind of just depends. It could be a little bit less, it could be a little bit more. However, at any point in time, if you need to take a break, please just get my attention. We will take a break. You don't need to tell me why. It's just, Judge, can we take a break? And we will take a break. All right, does anyone have any questions at this time about anything that I have just said? All right. Thank you, ladies and gentlemen. Thank you again for your patience this morning. There were several legal issues that the attorneys and I did need to resolve before we could bring you here into the courtroom. At this time, we will have opening statements on behalf of counsel, so on behalf of the state.
Thank you, Your Honor.
Your Honor, counsel, ladies and gentlemen of the jury. December 22nd, 2020 was a cold night in Columbus, Ohio. That night, Andre Hill drove to 1062 Oberlin Drive in Franklin County, Columbus, Ohio, to meet with Destiny, a woman who he knew who lived at that address at 1062 Oberlin Drive. Andre drove a silver-colored SUV to Oberlin Drive. The SUV belonged to his boss. Andre had been using the vehicle to work a job while his boss was out of town. The SUV was what many would consider to be a work truck, a work vehicle that was filled with tools and equipment. When Andre Hill arrived at Oberlin Drive, he parked the vehicle on the street near 1054 Oberlin Drive and waited for Destiny to come out to meet him. Because it was cold, Andre was periodically turning the vehicle off and on to stay warm over a period of a couple of hours while he waited. The periodic stopping and starting of the vehicle engine attracted the attention of a neighbor. It attracted the attention of the resident at 1054 Oberlin Drive. His name is Robert Ronker. Mr. Ronker was disturbed by the noise, the stopping and starting of the engine. So he contacted police to report it and was advised that an officer would be out to check on the situation. Mr. Ronker made that call just before 1:30 in the morning on December 22nd, 2020. As a result of that call, Officer Adam Coy was dispatched to Oberlin Drive. Upon arrival, Officer Coy was initially investigating a vehicle that was parked in front of Mr. Ronker's residence at 1054 Oberlin Drive. However, Mr. Ronker noticed that Officer Coy was looking at the wrong vehicle. So Mr. Ronker came out, approached Officer Coy to advise him that the vehicle in question had actually moved up the street and was now parked along the side of the street at 1070 Oberlin Drive. Officer Coy then moved his cruiser closer to the location where that vehicle was parked. Andre Hill was inside that vehicle. Officer Coy had a brief conversation with Andre Hill while Andre Hill remained in the vehicle. During that conversation, Andre Hill advised Officer Coy that he was waiting for someone, and he showed Officer Coy a text message from his phone that said, "I'll be right out," or words to that effect. Officer Coy then told Andre Hill that was fine, and he returned to his cruiser to wait for Andre Hill to leave. Around that time, a second officer, Officer Amy Detweiler, arrived on the scene. Officer Detweiler and Officer Coy had a very, very brief exchange about the situation and determined that they needed to approach Andre Hill, who had actually just entered the garage of the residence at 1062 Oberlin Drive, the residence where he was waiting on that person to come out. Now, Here, we have a photograph of that garage. At this point, Officer Coy and Officer Detweiler made their way up the driveway of 1062 Oberlin Drive towards the garage where Andre Hill was inside the garage. Officer Coy ordered Andre Hill to come out of the garage. Andre Hill began to comply with Officer Coy's orders and began to move towards the open garage door. He moved alongside a white car that was parked in that garage. Andre Hill had a cell phone in his left hand, which he had raised up towards the officers as if to show them something on the phone. His right hand was not visible. After Andre Hill rounded the bumper, the rear bumper of the white car, Officer Coy yelled "gun" and shot Andre Hill 4 times, killing him. The evidence will show that Andre Hill was not armed. He did not have a firearm. When the crime scene was processed, BCI agent Asia Chung recovered items at the scene, including a cell phone, including keys in the area where Andre Hill was shot, but there was no firearm. You will hear from a number of witnesses in this case, among them Officer Detweiler, the second officer who was there. You'll have the opportunity to view body-worn camera of Officer Detweiler, as well as body-worn camera of Officer Coy. Keep in mind, as you're viewing this, that the officer's body-worn camera was not on during their initial approach. So there are some portions of the events that were either not captured on video or that were captured without sound due to a feature on the body-worn camera that records the 60 seconds of video prior to the body cam being turned on, but records it without sound. In addition to viewing the body-worn camera, you'll also hear from Robert Ronker, the 911 caller, as well as other witnesses. Adam Coy has been indicted for 3 crimes. Those crimes include the crime for killing Andre Hill, a crime for felonious assault, and crime for reckless homicide. Let's run through what each of those entail. The first one, causing the death of Andre Hill. The state of Ohio has to prove beyond a reasonable doubt all the elements of these 3 offenses. What does the state of Ohio expect to prove? That the defendant, Adam Coy, caused the death of Andre Hill as a proximate result of committing or attempting to commit felonious assault, which is an offense of violence of the 1st or 2nd degree. That's the first offense. Now, as part of that, the state has to prove that the defendant, Adam Coy, acted knowingly in causing the death of Andre Hill. What is knowingly? A person acts knowingly regardless of purpose when the person is aware that his conduct will probably be of a certain nature or a certain result. A person has knowledge of circumstances when he is aware such circumstances probably exist. Because you cannot look into the mind of another, knowledge is determined from all of the facts and circumstances in evidence. This is that mental element that the state will have to prove. The second crime, which the state has to prove beyond a reasonable doubt was committed by Adam Coy, is felonious assault. What's felonious assault? What does the state have to prove? The state expects to prove that the defendant, Adam Coy, knowingly caused serious physical harm to Andre Hill, or alternatively, that Adam Coy caused or attempted to cause physical harm to Andre Hill by means of a deadly weapon. That's the second offense. The third offense is reckless homicide. The state has to prove beyond a reasonable doubt that the defendant, Adam Coy, recklessly caused the death of Andre Hill. And here we have a definition of recklessly, that mental element that we've been talking about. In order to prove recklessly, the state has to show a person acts recklessly when, with heedless indifference to the consequences, that person disregards a substantial and unjustifiable risk, that that person's conduct is likely to cause a certain result or be of a certain nature. A person is reckless when, with heedless indifference to the consequences, that person disregards a substantial and unjustifiable risk that such circumstances are likely to exist. The state of Ohio expects that at the end of this case, it will have proven to you beyond a reasonable doubt that the defendant, Adam Coy, is guilty of all three of those crimes. Now, the state also expects that the defense will assert that Adam Coy's use of deadly force against Andre Hill was reasonable and lawful in his official capacity as a police officer, and thus the state expects he will submit that he was justified in his actions. The defense will have an opportunity to present evidence to establish that defense called justification. In order to establish justification, the defendant, Adam Coy, has to prove that he was justified in using deadly force by a preponderance of the evidence. The state then has an opportunity to refute Officer Coy's use of deadly force was reasonable or justified. In order to do that, the state expects to call an expert witness, Seth Stoughton, to testify regarding national police practices, and the state expects that that expert will opine that Adam Coy did not act within those practices. Let's run through the justification, defense, and reasonableness. The standard for determining whether or not the use of deadly force by a police officer is justified is a reasonableness standard. If the officer reasonably believes deadly force is necessary to defend himself from the actual use of force or from the imminent use of physical force by a suspect that poses a threat of death or serious physical harm to the officer or others, then the officer's use of deadly force is not unreasonable. Keep in mind, reasonableness requires careful attention to the facts and circumstances. The reasonableness standard of a particular use of force must be judged by the perspective of a reasonable officer on the scene, not with the 20/20 vision of hindsight. The standard of proof for proving that justification defense is a preponderance of the evidence. That's the slightly more than 50% standard that you've heard about in voir dire. So in order to prove that he was justified in using deadly force, the defendant, Adam Coy, must prove that he was justified by a preponderance of the evidence. The preponderance of the evidence is the greater weight of evidence. It is evidence that you, as jurors, believe because it outweighs the evidence that is opposed to it. A preponderance means evidence that is more probable, more persuasive, or of greater probative value. It is the quality of the evidence that must be weighed. If the weight of the evidence is equally balanced, or if you as jurors are unable to determine which side of the issue has proven the preponderance, then the defendant, Adam Coy, has not established the defense of justification. The defendant, Adam Coy, may call his own expert witness to give an opinion about the events that occurred that night on December 22nd, 2020. And that expert may give an opinion as to whether or not Officer Coy's actions were justified. In addition to the opinions of any defense experts, you may also hear evidence related to Adam Coy's version of events that took place that night. The state of Ohio asks you to listen carefully to that information, to critically examine and analyze all of that information. This is something that you'll likely circle back to at a later point. Ultimately, ladies and gentlemen, the determination as to what happened that night and whether Officer Adam Coy's actions were reasonable or justified will be up to you. At the end of this case, the state of Ohio will ask you to find that Officer Coy's use of force was not reasonable, that Andre Hill followed the commands of Officer Coy, that Andre Hill was not a threat to Officer Coy or Officer Detweiler, that Andre Hill did not have a weapon, that Officer Coy's actions were not reasonable under the circumstances, and that Officer Coy was not justified in shooting and killing Andre Hill. At the end of this case, the state of Ohio will ask you to find Officer Adam Coy guilty of all three of the offenses with which he has been charged. Thank you.
Thank you, Ms. Hamlin. All right, on behalf of the defendant.
Thank you, Your Honor. May I proceed?
You may.
May it please the court, Mr. Collins, Mr. Coy, Mr. Pearson, and Ms. Hamlin. Good morning, ladies and gentlemen. The state of Ohio just told you that Adam Coy did not perceive a threat on December 22nd, 2020. The state's own witnesses will tell you that the fact that there was no weapon found on the scene does not matter, contradicting the state's theory. You are going to hear that officers do not have to wait until they see the glint of steel. That what matters is how the hand was being presented, because an action is faster than a reaction. The state's own witnesses are going to tell you that. You are going to hear that that is how officers are trained. You are going to hear from the state's own witnesses that actual possession of a weapon is irrelevant, that police officers are allowed to be mistaken. Whether you agree with that or disagree with that, that is what their training says. You are going to hear from the state's own witnesses that Adam Coy does not have to await the glint of steel in order to use deadly force. Now, you will hear that Adam Coy saw that glint of steel, make no mistake. He saw a glint of steel. He saw metal come up in a hand. And the state's own witnesses will tell you that police officers do not have to wait. They don't have to be 100% certain that that glint of steel that's coming at them is in fact a firearm. So we ask that you keep that in mind as you hold the state of Ohio to their burden and examine the credibility of the state of Ohio's case. You are going to hear that on December 22nd, 2020, my client believed he was going to get shot. He yells, "Gun, gun," steps off the line, draws his weapon, and fires at what he honestly believed was a revolver being leveled at his direction. You are going to hear that he was mistaken, that it was not a revolver, but instead, that glint of steel turned out to be a metal mass of keys. You are going to hear that police officers are allowed to be mistaken, and you are going to hear, ladies and gentlemen, that even though there was no weapon found, his action to respond with deadly force was consistent with national police procedures. And that is what the evidence will show. Now, opening statements. Just as the judge indicated, they're an opportunity for each side to lead you down a path of what each side believes the evidence will show. Or is, as the case here, it's an opportunity for me to lead you down a path of what we believe the evidence will not show. For instance, the state of Ohio just tried to tell you that our client was reckless when he made the split-second decision to use deadly force. However, ladies and gentlemen, the evidence will show that our client was not reckless. He did what he was trained to do. And what he was trained to do was shoot to stop the threat. The evidence will show he didn't act with heedless indifference. He didn't empty his clip. He was a trained officer doing what he was trained to do, to stop the hand with what he believed was a revolver being leveled at his direction. Now, every time Mr. Collins and I prepare for a case, we like to look for what we call a theme. And what I mean by theme, ladies and gentlemen, is when you have a case and examine a case, you have witnesses, some civilian, some professional. You've got some evidence, some physical, some circumstantial, and those all sit on the periphery of a case. But the theme, ladies and gentlemen, is what's at the core fundamental concept of a case. And so the theme of this case, the core fundamental concept, is one of justification. And that was because the mistake that Adam Coy made on December 22nd, 2020 was reasonable because he was acting in accordance with his training. Now that is because the evidence will show that on December 22nd, 2020, Adam Coy was justified when he made the decision to use deadly force. Because number one, he had a subjective belief that he was in immediate fear of great bodily harm or death. And number two, that belief was objectively reasonable based on the totality of the circumstances when viewed through the eyes of a reasonable police officer on the scene without the benefit of 20/20 hindsight. And that's because, ladies and gentlemen, the evidence will show that Adam Coy saw the glint of steel being leveled at his direction, believed it to be a gun. He was mistaken, and the evidence will show that that mistake was reasonable. And we will prove that, ladies and gentlemen, by a preponderance of the evidence, or more likely than not. And as the judge will tell you, if you find that we have met our burden of proof of more likely than not, if we have proven justification to you, more likely than not, then that serves as a complete defense to all three charges. Now, with the benefit of hindsight, nobody in this courtroom disputes that December 22nd, 2020, the events that occurred were tragic. And it's not lost on us that someone lost a life. Someone lost a father and a friend. However, as the judge told you and will continue to remind you, that when you examine a case, when you analyze and when you decide a case, you must not consider sympathy or empathy. And it is a tough task, ladies and gentlemen, because undoubtedly, the state of Ohio is going to try to use that we are all humans in this courtroom. I am warning you now that it's not easy, and it doesn't get any easier the more times you see a body-worn camera or the more times you see a gruesome photo. I am sure they will play the body-worn camera over and over and over again. They will slow it down for you, go frame by frame for you. They're going to show you graphic photos. They're hard to see. It's hard to hear. And it's hard because we ask you to be almost clinical in your analysis. But that's what the law requires. Again, whether you agree with it or disagree with it, that is what the judge has already told you, and I promise you he will tell you again. And so every time the state plays that video, or you see that picture, you see that body-worn camera go frame by frame, Mr. Collins and I would ask that you keep in mind that admonition that the judge gave you, that as you took an oath as a juror, you are not to consider sympathy or empathy when deciding this case. Now, unlike the majority of the cases that we try in our criminal justice system, we have a burden here. However, that does not alleviate the state of Ohio from meeting its burden. It is they that must prove to you, beyond a reasonable doubt, each and every element of all three crimes charged. Beyond a reasonable doubt is our highest legal burden in our system. As the judge will tell you, it's proof of such nature you would rely upon it in your most important of your own affairs: care for an elderly parent, surgery for a child. And if they fail to prove all of those elements to you beyond a reasonable doubt, the judge will tell you your analysis stops there. Now, you're going to hear two competing theories that the state is pursuing against our client. One is saying that he shot to injure Mr. Hill, that he knowingly committed a felonious assault, which proximately resulted in the death. The evidence will show that he's not trained to shoot to injure. He's not trained to shoot to kill, but rather the evidence will show that he is trained to stop the threat of what he believed to be a revolver. The second theory is that he did not act knowingly, but rather he acted recklessly, with heedless indifference concerning the consequences of his actions. Again, ladies and gentlemen, the evidence will show that Adam Coy did what he was trained to do on December 22nd, 2020. Not shoot with heedless indifference, but trained to shoot to stop the threat. The evidence will show they are not going to meet their burden of proof, because the evidence will show, ladies and gentlemen, that the state started from a premise and worked backwards. The state will not be able to prove any of the mental elements beyond a reasonable doubt because of those conflicting theories. The state's own witnesses will support the defense of justification. And the expert that the state is going to call, a man by the name of Seth Stoughton, he comes to multiple conclusions. Listen to those conclusions, ladies and gentlemen. One is contradictory to what the judge is going to tell you. And a separate conclusion is the same exact conclusion that the defense experts come to. And that is that he will tell you if an officer believes a gun to be pointed at him, then that officer is justified in shooting. So that is why the state of Ohio will not be able to meet its burden. And again, if that is the case, the judge will tell you your analysis stops. But even if you find that somehow, despite what I've just told you, that the state of Ohio does in fact meet its burden, then and only then do you analyze the defense of justification. And so this is the flow chart of how your analysis will go. First, you will analyze, did the state meet its burden of proof beyond a reasonable doubt? If no, your analysis stops there, and your verdict is not guilty. If yes, then you must analyze the defense of justification. You must ask yourselves, did the defense prove justification by a preponderance of the evidence, or more likely than not? If yes, then your verdicts will be not guilty, and if no, then your verdict will be guilty. Thank you, Your Honor. And so I want to talk about our burden, ladies and gentlemen. It's different than the state of Ohio's. certainly not as high as the state of Ohio's. But we welcome that burden, ladies and gentlemen. We have to prove to you that our client was justified by a preponderance of the evidence. As the judge will tell you, a smidge over 50%, or more likely than not. So as you listen to the testimony and the defense that we put on, remember, we have to prove two prongs to you by preponderance of the evidence. Number one, the subjective component, that it is more likely than not that Adam Coy had a belief that he was in imminent fear of great bodily harm or death. And number two, the objective component, that it is more likely than not that his decision to use deadly force was reasonable, given the totality of the circumstances in the eyes of a reasonable police officer on the scene, going through everything my client did on December 22nd, 2020. Now, this is where the mistake comes into play, ladies and gentlemen. In that calculus of reasonable, we have to prove that the mistake Adam made was more likely than not reasonable, given the totality of the circumstances. Again, we have to prove that by a preponderance. So I'm asking that you keep those two components of justification in the back of your mind as you are listening to the testimony here. Is it more likely than not than when Adam saw what he believed to be a gun? Is it more likely than not that he was in fear for his life? And number two, is it more likely than not reasonable that he made a mistake when he saw the steel, the metal that resembled a gun in both size and color? Now, your task is not an easy one, and the judge is going to instruct you that you must analyze that second component from the eyes of a reasonable police officer on the scene. You must examine the totality of the circumstances, and the judge will tell you, can't use hindsight in your analysis. The judge will tell you, you must account for the fact that police officers are often forced to make split-second decisions in circumstances that are tense, uncertain, and rapidly evolving about the amount of force necessary in a particular situation. And there's a reason why the law of justification, ladies and gentlemen, is written in this fashion. And that's because unlike judges, unlike juries, unlike me, officers on the beat are not afforded the luxury of armchair reflection. Every single day, our men and our women on our police force put on their uniform, not knowing if they're going to return to their home or their armchairs for doing their job. And the court will tell you that you have to take that into account, that they're required to do their job. Now, let me tell you a little bit about Adam Coy. 2 days after high school graduation, he joined the Army, was honorably discharged for fighting our country and earned a rank of Sergeant E5. He returned from the Army and immediately began his career in law enforcement. He's got 3 kids and a wife, and on December 22nd, 2020, he faced every law enforcement officer's nightmare. You are going to hear that on December 22nd, 2020, a little after 1:30 a.m., Adam was in the area of Ackerman and Olentangy when he was dispatched on a call for service to Oberlin Drive, 1054 Oberlin Drive. That was the first house that you guys went to on your jury view. He was dispatched on a 4848A, suspicious car, suspicious person report, because there was an SUV that had been turning off and on for some time. Adam arrived to 1054 Oberlin and approached that SUV that was in front of that address. The caller met Adam outside and told him, hold on, that's the wrong SUV. The SUV that was in front of my house had since moved, not to 1062, but to the third house that you guys went to, past 1062, down to 1070 Oberlin Drive. That SUV was in fact in front of 1054, but that suspicious vehicle had moved to 1070. So Adam pulls his cruiser behind the SUV and exited the cruiser, as he was trained to do. He pulls offset, meaning He pulls up behind the car, but not directly behind, a little bit offset, as he was trained to do. As he approaches the driver's side of the SUV, the driver rolls down his window, makes an X with his arms, with a cell phone in his right hand. He leans over as if he was hiding something. Before Adam can get a word out, he was shown this phone. And based on those actions, it was Adam's understanding that somebody was going to come outside, that he was waiting for someone. So based on these actions, the call, the fact that a suspicious person was sitting in a suspicious vehicle, that he appeared to be hiding something, that he was dismissive, that he seemed like he didn't want to speak to Adam Coy, that he appeared wide-eyed and jittery, Adam decided to watch, to make sure that what his understanding was, that this person was waiting for somebody, that was in fact the case. So he returns to his cruiser and he waits in the area. He wants to see, is a person gonna come out to the car, or is this person just going to leave? He's waiting for that. Now, what Miss Amlin didn't tell you, ladies and gentlemen, is that Adam gets back to his Columbus police cruiser. He opens the door. He sits in the cruiser with the door open, as he was trained to do. And after about 1 minute, the person in the vehicle opens the door of the SUV. He exits the SUV. As this is happening, Adam gets out of the driver's seat of his cruiser, stood next to his cruiser to observe what was going on. The person walks behind the SUV directly in front of Adam's cruiser, and he didn't go to the house that he was parked in front of. He didn't go up to 1070 Oberlin Drive. Instead, he went up to 1062 Oberlin Drive, and he pounded on the door. Nobody comes downstairs. Nobody turns on any lights. He waits and waits, just less than a minute, and then proceeds to pound hard on the front door again. Again, all while Adam is observing. There's still no movement in the house, and it has remained dark. The person who was pounding on the door walks back to his SUV, opens the driver's side door, leans in and is rummaging through some things as if he were looking for something. He then walks back toward 1062 again. And Adam asks, "Hey, what's going on?" And the person ignores him. Adam watches the person continue to ignore him, and as he's doing so, he keeps looking back to see what Adam is doing, seeing what Adam's response was. In the meantime, that is when Amy Detweiler pulls up. The state didn't want you to hear all of that in between, though. That is when Amy Detweiler pulls up, because she was dispatched too on the original suspicious person or suspicious call. The caller at 1054 comes back outside, and Adam yells at him to go back inside for his own safety. Officer Detweiler exits her cruiser, and she and Officer Coy briefly communicate about something not being right, not knowing what is going on with the person they were sent to investigate. In the meantime, Adam and Amy lose track of where the person went. He disappeared. It is pitch black, ladies and gentlemen, at 1 a.m. You had the benefit of going to the scene in the daylight. However, in the eyes of Adam Coy and Officer Amy Detweiler, it was pitch black that night. So, Officer Detweiler and Officer Coy do what they're trained to do. They begin to look for the person to investigate what is going on. It was pitch black in the dead cold of winter. And at this point, nothing is adding up to Adam, and he lost sight of him. At this point, he has a duty to go forward at this point. And he will tell you, "I didn't know what was going on. I thought maybe it could have been a burglary or something to that effect. But at this point, I had to go investigate because I had what's called reasonable articulable suspicion to potentially believe a crime was being committed or was about to be committed." Adam Coy approaches the pine tree that you saw located between 1062 and 1070 Oberlin. The garage door was open. Something again that is not normal at 1:30 or 2 o'clock in the morning in the middle of the winter during the holiday season. There's no light in the garage. Adam sees a white car parked. He has his flashlight and he's scanning the area around the house. Initially, he doesn't see anybody in the garage. Then he sees a glow from a cell phone. He flashes his flashlight in that direction and sees the same suspicious individual that was in the car that ignored his commands huddled in the garage. Amy Detweiler has a different view. She pursues up the driveway and is to the right of Adam. As Adam is walking up the drive, he says, "Show yourself, come out here, something's not adding up." The person turns his body with his shoulder partially bladed and begins walking toward Adam and Amy with his eyes fixed on Adam. The person has a cell phone in his left hand, raising about shoulder level. Adam will tell you that training dictates that he perceived that to mean he was being distracted, that was to serve as a distraction, because neither Adam nor Officer Detweiler could see the right hand. As he's approaching and as he clears the bumper of his vehicle, you will hear that Adam Coy believed a hand to be raising up, sees the metal glint of steel, yells, "Gun, gun," steps offline, and fires 4 times until he sees that threat stop and he sees that threat drop. He immediately hits his body-worn camera. Columbus Police body-worn cameras at the time only had a 60-second look-back period. So you're going to see that body-worn camera did, in fact, capture the shooting. The video does not have audio at the time of the shooting, but you are going to see how quickly this all happened, how quick Adam was forced to make that split-second decision. Now, he doesn't let Officer Detweiler go right up to the person because he believes that person still had a gun. Once safe to approach, Adam does so, and he doesn't see a gun. But instead, he sees a mass of silver keys on a key with a key fob. You will see this metal mass of keys, ladies and gentlemen. He realized he was mistaken about the massive keys being a revolver. He was in total shock, and he became physically ill. The evidence will show, ladies and gentlemen, that based on that account of events that I just told you, that we will have met our burden. Number one, that Adam had a subjective belief, that it was more likely than not that when Adam believed he saw a firearm in that hand, that he was more likely than not afraid for his life. And number two, that he was objectively reasonable, that his action to use deadly force was objectively reasonable based on the totality of the circumstances. His actions were reasonable because he acted in accordance with his training when viewed from the eyes of a reasonable police officer on the scene without the benefit of 20/20 hindsight. And even though that he was mistaken, the evidence will show that mistake was reasonable because the keys were both similar in size and color to that of a revolver. Now, Amy Detweiler, the state's own witness, is going to provide you corroboration of the defense of justification. She's going to provide you corroboration that Adam yelled, "Gun, gun," before firing. She's going to provide you corroboration that he does not let her approach immediately after because he still believed that a weapon was within reach. Now, the second prong of justification I want to focus on for a moment. How are you going to know what a reasonable police officer, how that person would have acted? How are you going to know about these national police standards that the state and I keep talking about? You're going to hear from 2 defense experts, decorated law enforcement officers with more years of law enforcement experience than I have on this earth. Between the 2 of them, they have trained thousands of law enforcement officers all over the world on deadly force. Particularly, they've trained officers in this city and in this state. Their names are Kevin Davis and Jim Scanlon, both certified trained police officers here in the state of Ohio and now retired. Kevin Davis has been in law enforcement for almost 40 years, and he's a certified force analyst. Jim Scanlon was a law enforcement officer for 33 years, 19 of which he served on SWAT. He started his own company in 1999, where he consults and trains officers with officers involved in shootings, firearms, hostage barricade situations, and critical incident training. Listen to the two defense experts and compare them to the state of Ohio's expert. The evidence will show that the state's expert does not hold a candle to the defense experts when it comes to qualifications. Now, Jim Scanlon and Kevin Davis use different methodologies in analyzing this use of force, but they are going to come to the same conclusion. They are going to tell you why and how Adam acted accordance with national training and police procedures. They're going to help you analyze what a reasonable police officer would do. Listen, as one of our experts will tell you why Hill's actions dictated what Adam did next. Then, after standing in Adam Coy's shoes, experienced what he experienced, as our expert will tell you, listen, as they will tell you it required immediate action on behalf of my client. One of our experts are going to walk you through some factors. These factors will be mentioned in the jury instructions that the judge will give you. Keep these factors in the back of your mind as our expert talks to you about them. Number one, the severity of the crime at issue. Listen, as our expert will tell you that Adam Coy had a lawful objective for taking action. He had a duty to go forward. He will tell you that there is no more severe crime, there is no more severe threat than thinking that a gun is being pointed at you as a police officer. The second factor, whether the person posed an immediate threat. Listen, as our expert will tell you, that officers are trained that the actual possession of a gun is irrelevant, that what matters is the perceived threat based on how the object in the hand was presented. There is no question, as the evidence will show, that based on training, when a perceived threat is a person with a gun, that they are an immediate threat. Evidence will show that Coy's decision to use deadly force when examining this factor is more likely than not reasonable. And the third factor that you will hear these experts discuss is whether the suspect was actively resisting or attempting to evade arrest. You're going to hear that the person was non-responsive, that he disappeared, that he ignored Coy. And so evidence will show that when you analyze this factor, it is more likely than not reasonable with his use of deadly force. You are going to hear, ladies and gentlemen, how officers are trained, what they are trained to believe as if it is second nature. You're going to hear about threat patterns that officers have to train to indicate, recognize, process, and respond to these threat patterns. You're going to hear that they are trained to know that an action is always faster than a reaction. You are going to hear from experienced, trained law enforcement officers that when a hand comes up, an officer does not need to be sure that there is a firearm in that hand before responding with deadly force. You are going to hear that Adam Coy waited until he saw that glint of steel come up in his hand. You are going to hear from experienced, trained law enforcement officers that an officer is allowed to be mistaken. And you are going to hear from experienced, trained law enforcement officers that a perceived threat is enough. You are going to hear and you are going to see why that mistake is more likely than not reasonable. In the dark, based on the totality of the circumstances. You're going to hear about the limitations of seeing in the dark. You're going to hear about the limitations of what the body-worn camera captures. You're going to hear time and time again that the camera does not capture everything that our eyes do. And you're going to hear and see everything that camera captured versus what Adam Coy perceived on that night. Now, the state's expert, Seth Stoughton, I think he was a police officer for maybe 4 years and 7 months. He's got no experience here as a law enforcement officer in the state of Ohio, and certainly not in the area where the shooting took place. But even he, a much less experienced officer, will tell you that if an officer believes a gun is being leveled at him or her, they are allowed to shoot. Even he will tell you that you need not wait the glint of steel. Even he will tell you an action is faster than a reaction. And even he will tell you officers are allowed to make mistakes. In recap, ladies and gentlemen, the state of Ohio has the burden of proof here. They have to prove to you each and every element beyond a reasonable doubt. If they do that, only then do you get to our defense of justification. Our defense of justification is more likely than not. And as the evidence will show, at the end of the trial, the evidence will show that it is more likely than not that Adam Coy believed he was about to be shot because he believed that that person had a firearm in his hand. And the evidence will show that based on the totality of the circumstances, in the eyes of a reasonable police officer on the scene, experiencing what Adam Coy experienced on that day without the benefit of 20/20 hindsight, the evidence will show, ladies and gentlemen, that that decision to use deadly force was more likely than not reasonable because he acted in accordance with his training, as he was trained to do. As such, at the end of trial, my partner, Mr. Collins, will come before you and ask that you find Adam Coy not guilty of all 3 charges. And that's because he was justified when he took those actions on December 22nd, 2020. I thank you for your time.
Thank you, Ms. Stevens. Counsel, please approach. Off the record. Okay, ladies and gentlemen, we're going to take about a 10-minute break. If I could get you back in the jury room at about 1:15. Remember the admonitions that I've given you with respect to discussing this case among yourselves or with anyone else. All rise for the jury. behalf of the defendant.
No, Your Honor.
All right, Mrs. Harper.
Your Honor, with the court's permission, I may slide a little bit or.
Right, where you need to be. All right, you may be seated, ladies and gentlemen. Okay, at this time, we will start with the state's presentation of its evidence. You may call your witness.
Thank you, Your Honor. State calls Robert Walker.
Good afternoon.
Good afternoon.
Please raise your right hand. Do you swear or affirm that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, as you shall answer unto God under the pains and penalties of perjury? You may be seated. All right, as you can see,
Okay,
there's a button.
okay, I got it.
It's on the other side. That one that locks it in.
Okay, I got it. Oh, yeah.
Okay, I'm gonna ask if you pull the microphone just a little bit closer to you. It is important that you speak into the microphone so that the ladies and gentlemen of the jury can hear you.
Okay,
It's also important that you respond to the questions that you do so verbally. It's hard to get things of that sort.
yes, sir.
If you would please state your name, spelling your last.
My name is Robert Ronker, Roenker.
Thank you. You may inquire.
Thank you, Your Honor. Good afternoon, Mr. Ronker.
Good afternoon.
Can you tell us how old you are?
I'm 76.
All right, and where do you live?
1054 Oberlin Drive in Columbus.
And is that in Franklin County?
Yes.
How long have you lived there?
About 45 years.
All right, and are you married?
Yes.
How long have you been married?
54 years.
And does your wife live at that address with you?
My daughter lives with me.
So your daughter, okay. So both of them live there, your daughter and your wife?
Yes.
All right. And are you retired?
Yes.
Where are you retired from?
Borden's Milk Company and Labatt Laboratories.
Abbott Laboratories?
Yes.
All right. And what did you do there?
The dairy, I was a milkman. I repaired feeding pumps for hospitals.
Okay. So I want you to think back to December 22nd of 2020. Okay, so about 4 years ago. Did you make a phone call to 911 on that date, which ultimately transferred you to a general police number?
Yes.
Did you make that phone call around 1:30 or so in the morning?
Yes.
All right. What did you see or hear that caused you to make that phone call?
There was a vehicle out in my front, and not the yard, but the street in front of my house, running, idling for a long period of times, and shutting off and turning back on. And my wife and I was kind of concerned about the vehicle being parked out there.
Okay. How would you describe the noise?
A loud muffler sound.
Okay. And approximately how long had that been going on before you made this call?
About 3 hours.
And are you able to describe the vehicle that was making these noises or that was shutting off and on?
Yes. It was a gray SUV, a Chevrolet, or some kind of a General Motors vehicle.
Okay. And now, prior to coming into court today, did you have the opportunity to review a recording of that phone call that you made before you came here today?
Yes, I did.
And based on your opportunity to review that call, would you say that it was a fair and accurate representation of the call that you made?
Yes.
Okay. Your Honor, at this time, the state would ask to play that 911 call.
Okay, is the 911 call marked?
I'm sorry, Your Honor. It is, I have it marked electronically. It's also on the list which counsel has. It's marked as State's Exhibit G.
Okay, thank you. Any objection?
No objection, Your Honor.
Okay. Yes, you may play.
All right, thank you. One second, Your Honor.
Okay.
It'd help if I plugged it in first. And I don't know, Your Honor, if there's, oh, it's come up. All right.
Columbus Police, Deck 22.
Yeah, my name is Robert Ronker, Roenker. I live at 1054 Oberlin Drive. That's Columbus, 43221.
Pause it right there. About 16 seconds in. Mr. Ronker, have you heard that?
Yes.
Is that your voice there?
Yes.
And is that the call that you made?
Yes.
All right. I'm going to resume at 16 seconds in.
A vehicle out front of my house, right beside of my house, in the street on a curve. It's been out there earlier this evening running, then they shut it off. Now it's back running again. It's been about a half hour. I figured it was a neighbor, but I figured if it's company for the neighbors, they wouldn't be out there running it for that long period of time.
Is there somebody in the vehicle, sir?
Oh, I have not go out there and checked. But it's, you know, you can hear it revving up a little bit.
You have a description of the vehicle?
Yeah, it's a gray Suburban or a Escalade or some big SUV from Chevy. I mean, I had to go out there, but I didn't. I don't want to get in trouble. I don't have a gun. And my wife's really concerned about it.
Can I get your name?
Her name?
No, your name, sir.
Oh, Robert
Okay, what's your phone
Ronker.
number?
614.
I'm going to pause it there at 1:39. Now, Mr. Runker, is this the phone call that you made?
Yes,
All right. And based on that call, did anyone respond to your address?
yes.
Okay. Who responded?
Columbus Police Department,
And did you see an actual officer respond?
yes.
Okay. Can you tell us about the interaction that you had with the officer? What was the first thing you did?
I was waiting for him, and when he pulled up to the house, I went out there to approach him and tell him the car, the SUV was out there, moved from the spot it was in, and I told him where it went.
Okay. So when the officer initially arrived, what was he doing before you went out and told him that information?
When he got a car, he was just looking at a neighbor's car at the street with a flashlight, and that's why I went out and I told him that was the wrong car that he was looking at.
Okay. So you let him know he was looking at the wrong car.
Yes.
All right. And then once you let him know that, what happened next?
Well, I just let him go do what he's got, and I started approaching back to the house.
Okay. All right. Did you see the officer have any interaction with the vehicle that you had pointed out to him, the one that was causing the disturbance?
He went to the car and looked around, I assume, and that was it, all I know.
All right. Now, after you observed the officer go to that vehicle, the one in question that you called about, what's the next thing you recall happening?
When I went up to the house, I was going back to the house and letting the officer do what he's trained to do, and I got up on my front porch. I had heard
Objection, Your Honor.
Okay, overruled that he heard, but counsel, please approach this for a second. Yeah, on. But thank you. Okay, the objection is overruled. Okay, you may inquire.
Thank you, Your Honor. So, Mr. Ronker, did you witness a female neighbor who lived next door to you outside?
Yes.
Okay. And without telling us what was said, did you hear or observe anything from her?
She was hollering.
Okay. She was hollering. And based on that, did that cause you to go to the officer to tell him something? Ever have other people living there with him? What happened? Go to the said, did and witness a female neighbor who lived next door to you outside.
Yes.
Okay. And without telling us what was said, did you hear or observe anything from her?
She was hollering.
Okay. She was hollering. And based on that, did that cause you to go to the officer to tell him something?
Yes.
Okay. And what did you tell the officer?
I told the officer, the lady at the front door of her house, she said the person in the vehicle was a friend.
Okay. And when you did that, what did the officer say?
He told me to go back into my house and he would talk to me later.
All right. So after that happened with the officer, and do you recall if the officer was male or female?
He was male.
All right. After the officer told you to go back into your house and he would talk to you later, what did you do next?
Well, I did what he said. I went back to my house.
Did you make it all the way inside your house?
No.
What happened?
I heard 2 shots.
Did you see those shots?
No.
So you heard 2 shots. What did you do after that?
Went back in my house.
Did you see anyone get shot?
No.
Did you see the person firing the shots?
No.
And did you hear any words or talking between the time that you left the officer and started walking back to your house until you heard gunshots?
No.
All right. Okay, so Mr. Ronker, I just want to have you point out a couple of things here. So your address, again, is what on Oberlin?
1054 Oberlin Drive.
Okay, and back then, did you know who lived next door to you?
Yes.
Do you know the address there?
1062.
All right. And who lived there?
Bill Wadley.
Okay. And did he ever have other people living there with him?
Yes.
Okay. The person that you said you heard hollering, that person, do you know if that person lived there?
Yes.
Okay. Now I'd like to show you a couple of photographs. Your Honor, if there's no objection, I'd like to use a couple of photographs.
Any objections?
No objection, Your Honor.
Thank you.
Okay. Mr. Ronker, can you see those photographs?
Yes.
All right, so we have here State's Exhibit A2, and I believe you have a laser pointer in front of you.
Yes.
If you could, can you just point out if you see your house in this photograph? And you'll have to actually point the laser pointer up towards this big screen
Oh,
that
I'm
everyone
sorry.
else is looking at. Okay. So that's your house right there?
Yes.
That would be kind of, would that be the one with all the lights in front of it?
All the lights, yes.
Those Christmas lights?
Yes.
All right. So that's your house at,
1054.
right. And then to the right of that, which house is that? Or, I'm sorry, to the left of that.
Right there, that's Bill's house.
Okay. And the address there is what?
1062.
And then we've got State's Exhibit A7 here.
Yes.
Do you recognize the houses here?
Excuse me. That house is my house, and that house is Bill's house.
Okay. Very good. That's all with the photographs, Your Honor. Mr. Ronker, you were talking about Bill, your neighbor.
Yes.
Does he still live there?
No.
What happened to Bill?
He passed away.
Thank you. Nothing additional, Your Honor.
Thank you. Ms. Amlin. Okay, cross-examination?
Thank you, Your Honor. Good afternoon, Mr. Ronker.
Good afternoon.
My name is Caitlin Stevens, and I, along with my partner, Mr. Collins, represent Adam Coy in this action. If at any time I go too fast or you don't understand the question, please just let me know and I'll rephrase.
Okay.
Thank you. You told the ladies and gentlemen of the jury that you're 76 years old, right?
Yes.
You just turned 76 yesterday,
Yes,
correct?
yes.
Happy birthday.
Thank you.
You're welcome. I kind of want to pick up where Miss Amlin left off. I want to focus on the second conversation that you say you had with my client. You were interviewed by police detectives 2 separate times for this case, correct?
Yes.
Once on December 22nd, 2020, right?
Yes.
And the other on January 12th, 2021, some weeks after the event, correct?
Yes.
Each of those times, sir, that you were interviewed, you told police that you were going to the other officer with what you heard, but he told you to go back in the house, correct?
Yes.
Okay, so you never said to those to those detectives who were interviewing you, hey, I told them what my neighbor told me, correct?
I don't understand that.
Okay, let me rephrase. It's a terrible question. I apologize. You told Miss Amlin that you went to my client and told him, hey, that's the neighbor's friend or family, correct?
Yes.
Neither one of those 2 times you were interviewed prior with those police detectives did you tell them that you told my client that, correct?
Yes.
Would it help if I refresh your recollection to play those interviews for you, sir?
Yes.
Okay. Your Honor, may I do that?
Not yet. Please approach. Off the record first. Okay, ladies and gentlemen, we're going to take about a 10, 15-minute break. If I can get you back in the jury room at about 5 till. Okay, at about 5 till. Again, remember the admonitions that I've given you with respect to discussing this case among yourselves or with anyone else. All rise for the jury. May be seated, ladies and gentlemen. If you could just cue it up.
Mr. Runker, I'm going to play for you an excerpt from your interview back on December 22nd, 2020. I'll play that one first. It starts at the 7-minute mark. I believe it'll be 7 minutes and 32 seconds, okay?
Okay, okay.
Judge, I think you have a question back there.
Yes.
Play audio now or no audio?
No, you can play audio.
Okay, just to make sure. Thank you, sir.
You're welcome.
Judge, do I have the
Oh,
audio? I
no,
apologize.
no, that's on me. I'm sorry.
It will actually start, sir, from the 7-minute and 27 mark. I apologize, I can't get it to the 32-second exact.
Right, wouldn't be so concerned, you know? So I was gonna go back to the police officer and tell him the girl was hollering at him. He told me I should go back in the house. I'll talk to you later. I'll come back in the house.
Okay.
That was your voice on the recording, correct?
Yes.
And you heard yourself say, I was gonna go tell the police that, but then he told me, go
Hold tight.
back in the house.
No, he's just refreshing his recollection.
I apologize.
Because we're going to have to get the jurors back in for the questioning.
I apologize, Judge, thank you.
Okay.
May I play the second recording?
Correct.
Thank you. Mr. Ronker, I am now going to play the second recording from the follow-up interview on January 12th, 2021.
Okay. She said, he's a friend. I don't remember if it was a friend. I said, oh. So I got off the porch and went down towards the officer and said, sir, because I wanted to clarify something.
Right.
But he told me, sir, you go back in the house. I'll talk to you later.
Was the other officer?
Was that your voice on that recording?
Yes.
Did that refresh your recollection about what you told the police officers back on those two respective dates?
Yes.
Thank you.
Okay, thank you. Okay, any objection at all on behalf of the state that we need to deal with at this point in time with what was played?
No, Your Honor.
Okay, all right. Anything we need to supplement?
No, Your Honor.
Okay, all right. Looks like I sent them out too long. So for all of us here, let's take 10 then. may be seated, ladies and gentlemen. All right, we'll continue with cross-examination. Ms. Stevens?
Thank you, Your Honor. Mr. Ronker, so you would agree with me that after hearing your voice, that you never told the detectives that you conveyed any information to my client, correct?
You know, I don't understand that. I don't understand, you know, it's kind of, I mean, I don't understand your question.
Okay. On December 22nd, 2020, you told the detectives, so I was gonna go back to the police officer and tell him the girl was hollering at him, and he told me I should go back into the house. I'll talk to you later. I come back in the house.
Yeah, that's correct.
Correct? And on January 12th, 2021, you say to the detectives, I don't remember. I said, oh, so I got off the porch and went down towards the officer. I said, sir, because I wanted to clarify something. Well, he told me, sir, you need to go back into the house. I'll talk to you later, correct?
That is correct.
So you never told the detectives that you told my client anything that your neighbor may have said to you, correct? You didn't get that far, sir, correct? Because he told you, sir, go back in the house.
That's correct.
Okay. I want to back up to the 911 call. You made that 911 call we've established, correct?
Yes.
And you made that call because you and your wife were very concerned, right?
Yes.
You were concerned because that type of behavior with that car was unusual for your neighborhood, right?
Yes.
You had concerns about a potential car break-in
Yes.
or house break-in.
Yes.
And so that's why you called 911, right?
My wife was concerned.
And certainly you were also concerned.
Yes.
You made the call after 1 a.m., right?
Yes.
And at that time, sir, it was pitch black outside, right?
Yes.
After you made that call, you watched the SUV move from 1054 down to 1070, right?
Yes.
That's 2 doors down from you, correct?
Yes.
If you're looking at your house, it would be 2 houses to the left, right?
Yes.
And if you're looking at your house, 1070 is probably, you would estimate, maybe 50 yards away?
Well, a little farther than that, yes.
Farther than that?
Yes.
Would you say 75 yards away? I say yards, sir, because I'm equating it to a football field.
Yes.
Okay. Around 75 yards away.
Well, I 50.
Okay, perfect. And so you saw the original officer, you saw a male officer arrive, correct?
Yes.
And you alerted him, hey, the SUV that was here, it's no longer here. It's down at 1070, right?
Yes.
I want to talk to you, sir, about some things that you did not see on December 22nd. You never saw the driver of the SUV walk into the garage, correct?
No.
You did not know that the second officer that pulled up was a female, right?
No.
You never heard any conversation between my client and the person in the SUV, right?
No.
Fair to say you probably wouldn't hear a conversation from 50 yards away, right?
No.
Your porch is, you were outside when you saw the brief interaction with my client, correct? I apologize, that was a terrible question. You were outside when you saw the officer approach that SUV, correct?
Yes.
Okay, sir, I've just got one more question for you. My understanding is you have a birthday dinner tonight, so what will you be ordering to eat?
Steak.
Steak, good for you. Happy birthday, sir. That's all the questions that I have for you right now. Ms. Amlin may have some additional questions. Thank you so much for being here.
Thank you, Ms. Stevens. Redirect.
One moment, Your Honor.
Okay, take your time.
Mr. Ronker, you were asked some questions about the SUV that you made the phone call about to the police department. a few minutes ago by Ms. Stevens. Do you remember that? She was asking you some questions.
Yes.
So, did you ever see a person or the driver of that SUV?
No.
Did you ever see them get in or out of a car?
No.
Would you even be able to tell if the person was a male or female?
No.
So, would it be fair to say you only saw the vehicle?
Yes.
Nothing further.
Thank you, Ms. Amlin. Recross?
No, thank you, Your Honor.
All right. Mr. Rumpke?
Oh.
Yeah, you can step down, sir.
Oh, thank you, sir.
State may call their next witness.
Thank you, Your Honor. State would like to call Officer Amy Detweiler.
Good afternoon. Could you please raise your right hand? Okay, do you swear or affirm that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, as you shall answer unto God under the pains and penalties of perjury?
Yes.
May be seated. All right, there is a microphone in front of you. I'm going to ask if you just pull the microphone down so that you can talk into it. It is important that you speak up loud enough so that the ladies and gentlemen of the jury can hear.
Yes, sir. Can you hear me okay?
All right. And then it's important that you answer verbally, sometimes difficult to interpret, things of that sort.
Yes, sir.
Okay, for the record, if you please state your name, spelling your last.
First name is Amy, last name is Detweiler, spelled Detweiler.
Thank you. You may inquire.
Thank you, Your Honor. Officer Detweiler, thank you for being here today. You are employed with the Columbus Division of Police, is that correct?
Yes.
How long have you been employed there?
To date, roughly 13 and a half years.
Okay. And in what capacity are you employed?
I am a patrol officer.
Did you have any other law enforcement job before coming to Columbus Division of Police?
No, sir.
And you said you've been with the division for 13 years?
Yes, sir.
All in the capacity as a patrol officer?
Yes.
What are the duties and responsibilities of a patrol officer here in Franklin County, Columbus?
Day-to-day tasks could be as simple as working traffic or traffic patrol, so you're just out and about in your cruiser. But mostly for us, we're busy, so it's just general calls for service that we would get dispatched to.
What are some of the types of service jobs that you get dispatched to?
Disturbances, unknown complaints. Obviously, we have higher-end burglaries, shootings. Could be well checks. It could be traffic complaints, and myriad of burglary reports, on-view robbery. I mean, there's many types of calls for service.
Okay. And what do you have to do to become a Columbus police officer?
You need to go through the Columbus Police Training Academy. So you have to obviously pass the initial steps to get in through just the process of hiring, and then you go through the Columbus Police Academy, which is at the time was a 6-month academy for me. It's now 7.5 months now, roughly.
Okay, I'm sorry to interrupt you. When did you go through the academy?
I'm sorry, 2011.
Okay, so in 2011, there was a how many month training academy?
6 months, I believe, at the time.
6 months. Okay, I'm sorry. Go ahead.
After you graduate the academy and all the aspects there, so you're learning legal, patrol aspects, things of that nature, then you would do a 4-month field training. So that's 4 different months with 4 different field training officers that teach you how to practically apply what you've learned in the academy.
All right. So are you assigned to like a senior officer and do a ride-along and are partnered with them for a period of time?
I would be assigned a field training officer, which I am a field training officer now. So you're assigned with somebody and you learn, again, how to practically apply what you've learned in the academy to the street. And then obviously once you pass field training, you would then be on patrol on your own.
So you were working in the capacity as a patrol officer in December of 2020, is that correct?
Yes.
Did you work any specific shifts or anything like that?
At the time, I was a Zone 4 evening midwatch.
Can you explain to ladies and gentlemen of the jury what a Zone 4 evening midwatch is?
The city of Columbus is broken into zones. There are 6 zones now. At the time, there were 5. Each one of those zones at the time had 4 different precincts. Zone 4 was North and South Linden, as well as Clintonville, and then the campus area. Evening midwatch is a shift that overlaps shift change. So my time of arrival would be 7 p.m. and I would be done at 5 a.m. versus a true first shift, second shift, or third shift officer.
Do you recall the evening of December 21st to December 22nd, 2020?
Yes,
What time did your shift start?
7 p.m.
And were you assigned a specific car or anything like that?
That night I was 90/30.
90/30?
Yes.
And did it start off as a regular evening of runs and general duties of a patrol officer?
Yes.
And what time were you expected to get off the following day?
5 a.m.
So it was a 7 p to 5 a
10
shift?
hours. Yes.
I'm going to fast forward to about 10 o'clock that night. What do you recall happening? What were you doing?
10 p.m.
Yes, I'm sorry, 10 p.m. on the evening of December 21st. Anything of significance?
I don't recall if I was on a run or not on a run at 10 p.m.
Okay. At what point in time did something of significance happen that you do recall?
After being dispatched to the Oberlin address. So 1:30-ish, if I recall.
So you recall at about 1:30 you're dispatched to the Oberlin address, and that would be 1:30 a.m. on the morning of December 22nd.
Time frame, yes.
Yeah. Do you recall where you were when you got that notification?
I believe I had just finished eating, and it was in the area of our substation. I was working on a report, so Cleveland Avenue and 11th, roughly.
And you, how did you get that call to dispatch there? Did it come in? I'll let you answer. How do those type of runs come in?
It's going to be an audible dispatch from our dispatcher, and then it's also going to come through on our MDC. So it comes through as a run that pops up on the computer as well.
Okay.
So it's visual and audio.
I see a lot of officers, they have like walkie-talkies or whatever you want to call it on their shoulder.
Yes,
What is that called again?
it's a walkie.
Walkie, sorry.
I do have one. I just don't have the mic is not up across me. So
Okay, but you had one at that time.
yes,
Did you receive information over there as well?
yes, my radio would have been on.
And what was the nature of the call, if you remember?
It came in as a 1016, which is a disturbance call. It was a silver SUV turning the engine on and off. It was parked in front of a residence.
So you got that information. It sounds like a little bit of detail, a vehicle turning on and off.
Yes,
Do sometimes you get called out for one thing and then it morphs and changes into another thing?
yes.
But that was the information that you got at the time, is that correct?
That was the initial call for service.
Now, were you directed to go there yourself, or is this a situation where you hear something over the radio and you chime in and say, I'll take that? How does that work?
I was specifically dispatched, so it was 9030, and I was also dispatched with 9031. So two officers were dispatched in two different cruisers.
So you heard 9031. Do you know who the occupant of that vehicle was?
Officer Coy.
And you had known Officer Coy for some time, is that correct?
My entire career.
What did you do next, Officer Detweiler?
I would have responded to the radio that I was receiving a call, so I would generally say I copy. And then also I would hit what's called a en route button. It's just a button that pops up that'll clear that screen from being on your screen. So both those tasks.
So you head out there to the Oberlin address?
Yes.
Is this a lights and sirens call, or is it just go there and get there with caution? What was your urgency at that point in time?
Would be following the traffic law call for service. So I'm just going to drive there as I would normally drive there, no lights and sirens.
Can you talk about that for a bit? What are the levels of, I guess, urgency that you're able to take when going to a scene or a location?
Priority 1 runs, some priority 2 runs can be responsive emergency lights and sirens. So you would see the audible beacons and a siren. And there are runs that are priority 3 or 4 that wouldn't require that type of response or that type of urgency. Now, any run can morph into that depending on what you're getting over the radio. Can make an executive decision on type of response if I feel like it needs it. In this particular case, just came in as a disturbance. It didn't require lights and sirens, no.
Okay. Can you tell the ladies and gentlemen of the jury what type of offenses fall into those different priorities? Obviously, you can't think of them all right here on the spot, but just give us some
Priority
examples.
1 right off the bat would be a shooting. So that would be the most obvious, or some sort of in-progress type run. Something that would require an emergent thing. It could be a DV if it rises to that, if you hear that there's some sort of exigency or urgency that's coming over the radio. But it's going to be your in-progress calls for service, things of that nature. So for just being general, priority 2 would fall into that as well. It just kind of drops down into, it could be a 17. A DV is going to be that where there's urgency there. That's something that we need to go for a violent offense, but wouldn't necessarily mean that we would be responding lights and sirens. Dropping it down to a level 3 would be a paper type run, or that could be a level 4 as well, priority 4. So it just, traffic complaints or some complaints are going to rise because they become priority. So I might run to something that's hazardous on the roadway, could become a priority run based on where it is located. If it's on the freeway, I might require a lights and sirens run or some kind of response if somebody's stranded. So those can all vary based on what they are. Typical paper runs are not going to be at some general runs or calls for service. Unknown complaints, unless you're getting information that would require lights and sirens or some kind of urgency, you would, again, just obey traffic law as you're driving to the run.
Okay. And again, what priority was this?
It's the 3, I believe.
So you head to the Oberlin address, and what happens next, Officer Detweiler?
I pull onto the street, and I observe, so Officer Coy had already parked and was outside of his cruiser. And I continued past, so the dispatch location, there was no one in front of that location any longer. Everything was up west of that location. So I proceeded to drive up and parked offset from where his cruiser was and exited my cruiser.
Okay. What happened when you exited your cruiser?
When
officer?
I was pulling up, I observed there was a white house with an open garage. And then I observed a male walking from the vicinity of the silver SUV in the direction of the house with the open garage.
Okay. Do you recall what that male looked like?
So, male.
Okay. Was he tall, short?
Taller than me, for sure. Stocky. Lighter skinned, I don't know, white at the time, I didn't know. And just walking away. I don't know if he had a hat on, he might have had a beanie on.
Okay. So pretty unremarkable?
Dark jacket on, yeah, nothing remarkable.
All right. Could you tell if he was holding anything in his hands?
No.
Were you close enough to be able to determine that, or is just not something that you had noticed when you pulled up?
Didn't notice when I pulled up. It was also cold outside.
Okay. I'm sorry, I didn't hear that.
It was cold outside, so I don't know. I didn't notice his hands.
Okay. And so you see him walk up to, where did he go?
Is it 1060 Oberlin?
Okay.
He walked in that general vicinity. So at the particular time where my cruiser was positioned, I couldn't see it was obstructed by a large tree. But I had watched him walk in the direction of that open garage. And that's all I knew up until that point.
All right. And what did you do next, Officer Detweiler?
I had a brief interaction with Officer Coy. I think I said something like code 4. So just so you have an understanding, if I don't have a role in a run, so it's not unusual that 2 officers might be dispatched somewhere and that the first officer could handle the situation and my services aren't needed, so to speak. So it could be anything. So I believe code 4, like maybe was he sleeping? I believe that's what I said. And he said—
I'm sorry to interrupt. You asked Officer Coy, was he sleeping?
Those are things that are going through my head.
Yeah.
Yeah. He said no.
Okay. And what else was in your conversation or
It
interaction?
wasn't much of a conversation. He informed me that we were brief about the tag. I think I said tag. He said doesn't come back here. He's trying to get into that house.
Let's back up. What does that mean? Tag doesn't come back.
License plate. So when you run an individual's license plate, it comes back to the registered address. Okay? In this particular case, that vehicle, when you run that license plate, does not come back to Oberlin's.
Okay.
Or an address on Oberlin.
So it was your understanding that Mr. Coy ran the license plate to see if it was stolen or something like that?
Yes.
And that's normal, what you all do?
Yes.
So you run a license plate to see if it comes back stolen, and your understanding was that it was not stolen?
No, we run a license plate to see if it belongs to the location. That would answer a question immediately. And you obviously want to know information about the car or the registered owner.
Okay. And his words to you were tag?
I believe I said tag.
Mm-hmm.
Meaning, there's not a lot of conversation. We don't need to have a lot of conversation to get to the point that we need to.
Right.
I'm asking if the tag, meaning does it come back here? It's just how and I was given the information that no, it doesn't come back.
Okay.
Meaning it does not come back to Oberlin.
Okay. So he relayed information to you that license plate did not register to the area of Oberlin?
Yes.
Okay. And did he say anything else of significance?
That he was trying to get into that house.
And what did you do at that point in time, Officer Detweiler?
I believe again, there was the garage was obstructed. I had to move backwards more towards my cruiser in order to get a view of the garage, which was blacked out, meaning, nothing tripped that caught my eye. So if he was in there or whatever, I had to rock back and shine my light into that area.
Okay. You said tripped. Are you referring to like garage?
Threshold trip. So, example, some folks would have on their garage door, there are sensors at the very bottom, and when you walk across that sensor, the light would then come on.
Okay.
There was no light that indicated that anybody had walked into the garage that would alert me to that right away.
Okay, so that garage was still dark.
Still dark.
And what did you do as a result of that?
Shine my flashlight into the garage.
Okay. What was Mr. Coy doing?
He had moved with me. We were both looking in the garage.
Did he shine his light there too?
I don't recall, but I would assume so. It was dark out.
Okay. And did you have your weapon out at that time, Officer Dell? Okay. At some point, did you go up to the garage to see the individual who had walked in there?
Yes.
All right, tell us about that.
After shining the flashlight into the garage, observed the male that looked like the same male that had walked into that general direction inside the garage. And initially, he was in the back towards the garage. There was one white vehicle parked in the garage. At the time, I couldn't tell you. It looked like a double garage, but it was only one vehicle in the car parked on the right side of the car. right side of the garage. And the person was inside the garage. I couldn't see, could only just really see the upper shoulders and head.
What blocked your view? The vehicle?
Yes.
And then what happened next, officer?
There was a determination that, well, he wasn't going in the home. He didn't go in the front door. He wasn't being let in. He was inside an open garage. There's no resolution to our situation, therefore we must make contact.
What was he doing in the garage?
No idea.
Okay. So you couldn't observe him doing anything except for standing there?
When we initially decided to make approach, I have no idea what he was doing. I couldn't see anything other than like the upper part of his body and his head.
Okay.
He was not facing us, he was facing away.
So you were on the right side of the driveway, is that correct?
At this time, we're still at the cruisers. So
Okay.
we hadn't started, I mean, this is seconds, so
Yes.
we decide that obviously we have some things that have occurred and we now need to have a conversation with the individual inside the garage.
And you said that you use shorthand and things like that because it's a situation where you sometimes need to react fast, is that right?
Yes, and we've been working together for a while. We just understand how to handle calls for service.
Okay. And what was your understanding of how you were going to handle this call at this particular point?
Well, we needed to make contact with the individual inside to determine why he was at the residence. He was not gaining access, he was not being let in. So we need to verify that he's to be there.
Okay. So what was your intention at that point, officer?
To investigate potential crime. It could be burglary, it could be trespassing. There's something going on, so we must make contact.
Okay. So would it be fair to say a lot of times you don't know what the situation is until you talk to someone? Is that correct?
Correct.
So you walk up the driveway, is that right?
Yes.
And Mr. Coy walks up the driveway as well?
Yes. We do not walk up. We walk up together, but not together. So we are not walking side by side. That is tactically wrong for the police. So I am walking in a straight path. We're up the garage driveway on the right side. He takes a more of a tactical line at an angle. So we're coming in.
Okay. And what happens as you progress? Is your weapon out?
Yes.
Okay. So you make that decision at the time you start to progress toward the garage door?
Yes.
What happens when you get to the front of the garage door, officer?
I don't go all the way to where the threshold would be, so I stop short of that. It might have been 7 feet, 8 feet. I don't know the exactly. Officer Coy gave the individual inside had moved from a position more towards the front of the vehicle to over towards the side, so now standing on the passenger side of the vehicle facing what I believe was an interior door, and was just facing that door again, not making entry. Officer Coy gave him the command to come outside, to come out.
Okay. And what did he do in reaction to being asked or told to come out?
It was a pause. It was a kind of a, I don't know how to describe it, just it wasn't a quick decision. He didn't sprint out, but he didn't come out right away. He did sort of pause and then turned towards me, raised his cell phone in his left hand, or he pulled his cell phone out or had his cell phone in this position.
Okay. How could you tell that it was a cell phone?
The screen was illuminated.
Okay, so he didn't show the back of it to you. He showed the front of the illuminated screen to you.
Yes.
And he began to walk out. Is that correct?
Yes.
All right. So what happened then, officer?
The screen was illuminated, so for whatever reason that was done, and I looked right at the cell phone, and I for whatever reason I stayed on that cell phone. And when I don't know what type of vehicle it was, a smaller, maybe mid-size sedan.
Like a mid-size Nissan, something like that?
Yes, sir. So he was a larger, taller male, so he only took a couple of steps before he hit the corner of the bumper. So, but he was coming at me with the cell phone out. I looked right at it, so I was paying attention to that cell phone. And he turned the corner of the car.
Okay, what happened when he turned the corner of the car?
He turned the corner of a car. I heard gun, gun. He's got a gun. He's got a gun in his other hand.
Okay, and who said that, Officer Detweiler?
Officer Coy.
And what happened as Mr. Coy yelled, gun, gun? What did he do? I'm sorry, what did Mr. Coy do?
He fired his weapon.
Do you recall how many shots he fired?
4.
And what did you do, Officer Detweiler?
I had raised my gun, but I had moved. There was shrubbery to my right. I had raised my gun and moved to the right to try to find cover.
At the time that this individual was walking out of the garage, could you see, you said you could see his his left hand with the cell phone illuminated. Could you see anything in his right hand at all?
I could not see the right side of his body.
Is that why you did not fire your weapon, officer?
I did not see anything presented to me because he was turned. So there was nothing for me to see other than the cell phone.
Okay. And so after Mr. Coy fired those 4 shots, what happened to the individual who was coming out of the garage?
He fell to the ground.
And walk us through the progression of events after that, officer. What happened?
He fell to the ground, away, so back to the driveway, so inward facing into the garage towards the bumper, towards the rear of the car. So on his side, so it would have been on his right side, belly to the garage, back to me.
Okay.
From there, I initially went to go handcuff, or to go in. Officer Coy yelled for me to stay back, because we hadn't located, there was still a firearm at play and we couldn't see his hands.
Okay. And what did you do then?
He was yelling, "Let me see your hands." I mean, we're still actively anticipating a firearm. And so there was a lot of yelling for hand commands. "Let me see your hands. Let me see your hands."
Did you ever locate a firearm? Or I'm sorry, let me rephrase. Did you ever see a firearm?
I did not see a firearm.
At some point in time, you approached this individual, is that correct? Who was on the ground?
Yes.
Okay, what happened when you approached him?
We were looking, patting him down, looking for a weapon.
Okay.
At some point in time, that's what's occurring. Can't see his hands, need to make sure we get in there. We have to make a decision. If he's not responding to loud commands to show his hands or any of that, and we have a deadly force threat, then we're gonna pause. Then at some point in time, the decision is made that we have to go in and try to locate that threat before anything else happens.
All right. At what point in time did you get on your radio and call for, or I guess call for help or anything like that?
Immediately. Well, it was seconds after, but there was not much delay.
Okay. And who did you call?
Well, it's not. I just aired on the radio that we had shots fired.
Okay. So when you hit on that walkie, that goes to your, where does that go?
Well, it's an open air, so it goes to everybody who's on our zone can hear that, as well as our dispatcher.
Okay. And what things did you ask for?
I aired that there were shots fired, I aired for a medic, and I aired for officer support.
Shots fired. I know it sounds obvious, but what type of effect does that have on the police force surrounding?
Well, it can be vague, because shots fired can be that you've observed shots fired or that you were actually in a shooting. In this particular case, that's what came out of my mouth, shots fired, shots fired, shots fired. Other officers are going to listen to tone and inflection in an officer's voice as well as your dispatcher. So I think it was quickly apparent that something had occurred.
Okay. And what did you do after that, officer?
Aired for officer support and a medic.
What is officer support?
Officer support would be other officers who have been involved in such critical incidences as this, it was a requirement, our part of our policy. So officer support would come and assist those who've been involved in such an incident.
Okay. So if this type of incident happens, one of your requirements is to notify officer support.
We air for officer support.
Air for officer support. And that's what you did in this instance.
Yes, I believe Officer Coy actually said, "Get me officer support," and I did.
All right. What did you do next, Officer Detweiler?
For whatever reason, I went and got scene tape.
Okay.
Started drifting down the driveway.
So you went and got scene tape and start to secure the scene?
I did move my cruiser so that the medics could come in. My cruiser was in the middle of the road.
Okay.
So I relocated my cruiser. Yes.
Why is securing the scene important?
Well, we just had a shooting, and we need to secure any evidence or anything needs to stay put. So other officers are going to come in, and we're going to secure everything so we don't have any outside influences or outside sources or anything going on. We have to find if there's any witnesses or whatever. It's scene security for any type of scene.
Okay. How long did it take for officers to arrive?
I don't know.
Okay.
It didn't seem like, we were in the western edge of 3 precincts over by Riverside Hospital. Many of the officers that could show up could come straight down North Broadway, so I don't know if it was a minute or 2 or less. Concept of time, I'm not sure.
All right. So at some point in time, other officers started to arrive. Is that correct?
Yes, as soon as I would air what I aired, they're all coming.
What is Mr. Coy doing at this time?
I don't know.
Okay. Would it be safe to say that you were focused on other things?
Yes.
Your Honor, could I get Officer Detweiler, can you take a look at State's Exhibit A2? Does that look familiar to you?
Yes.
Okay. What is that, Officer Detweiler?
The cruiser that you see is 9031. It's Officer Coy's cruiser. That's the silver SUV that we were called for.
Okay.
And the house to the right there, not the house with the blue shutters, the house to the right is the driveway where the shooting occurred, garage.
Okay. State's Exhibit A3. What is this a photograph of?
Officer Coy's cruiser.
Okay, just taken from a different angle.
Yes, sir.
And we also see the silver SUV in front, correct?
Yes, sir.
State's Exhibit A4. That'd be another photograph just taken from a different angle.
Same 2 vehicles, different angle.
State's Exhibit A5. What do we see here, Officer Detweiler?
I believe it's 1062. I think I had the address wrong. But the Oberlin address is the address there on the right with the open garage.
Here?
Yes.
Okay. And this is scene tape, correct? The yellow tape here and there.
Scene tape.
All right.
Yes.
State's Exhibit A6. What do we have here, Officer Detweiler?
This would be the east side of the house. There to the right is the Oberlin address. So you are east of that right now, and you're looking down Oberlin west. So again, that's Officer Coy's cruiser in the distance and the silver SUV there against the curb.
Okay. State's Exhibit A7. What do you have here, Officer Detweiler?
That's the Oberlin address from a different angle.
Okay. State's Exhibit A8.
Same house, different angle.
Okay. And we see a vehicle in the garage, correct?
Yes.
And is that the vehicle that you were describing earlier?
Yes.
State's Exhibit A9. What do we have here?
Again, that's Officer Coy's cruiser and the silver SUV. You're just east of that, so you're looking west. And the Oberlin house would be off to the right and east.
Do you recall moving your vehicle prior to these pictures being taken?
Yes,
All right. First of all, why did you move your vehicle?
to allow medics to come through. I was parked in the middle of the street.
Okay. Looking at this photograph, where in relation would your vehicle have been parked?
Behind, not directly behind Officer Coy, but behind Officer Coy and then offset to the left.
Okay. So it looks like Mr. Coy's vehicle is offset a little bit from the SUV. You would be offset more, correct?
Yes.
State's Exhibit A10. What do we have here, Officer Detweiler?
The Oberlin address looks like more from a straight-on view, but same house, different angle.
Okay. Now, when you arrived with and saw Mr. Coy there, was there lighting in the area similar to this, or was it different, or darker, lighter? Or do you recall?
These pictures look like some daylight is happening. It was dark, so it was between 1:30 and 2 in the morning, so it was dark. Other than, I mean, all these lights on the driveway, these are false lighting. So the only light would have been that light that's on the house.
Okay. Do you recall that light being on at the time or not?
I don't recall.
Okay. State's Exhibit A19. You see more lighting, more illumination. Is that right?
Yeah, it's daylight and there's false illumination, so.
Okay. State's Exhibit A20. What do we have here, Officer Detweiler?
It's the Oberlin address with the open garage and the white midsize vehicle inside.
Okay. And this photo is substantially similar to the conditions that night, except for the lighting.
Very bright. It was definitely not bright.
Okay. But I'm asking more specifically about the items are relatively the same.
The car and the garage, yes.
Okay. State's Exhibit A25. Can you use this photograph and talk about where Mr. Hill or the person who came out of the garage was when you shined the light on him? And if you need a laser pointer, I can give you one.
There's one up here.
Okay.
Excuse me while I try to operate the, okay. So I did not see this as not the original, I did not see, so this is not a very good angle from where I was standing, but somewhere in this, he was back in here, and then he was over in this area. But this is, I can't tell from this picture, but that's the general area. He starts out back here, behind, in the front towards the car, and then over here.
Okay. Thank you. So after you put up scene tape, you make the various calls on your walkie, you move your vehicle, is that correct?
Yes, sir.
For medics to arrive?
Yes, I was parked in the middle of the street. I needed to move so they could get in.
Okay. And other officers arrived and the medics arrived, is that right?
Other officers started arriving. At some point in time, the medics arrived, but I can't give you that timeline because I wasn't focused on that.
Okay, yes, understandable. It's fair to say that in these situations, sometimes time travels faster than you recall and sometimes slower than you recall, right?
Yes.
On or off the record? All right. Excuse us, ladies and gentlemen. Counsel, please approach. All right, ladies and gentlemen, we're going to take about a 10-minute break. If I can get you back in the jury room at 3:20. Okay, at 3:20. Again, remember the admonitions that I've given you with respect to discussing this case among yourselves or with anyone else. All rise for the jury. Thank you, everyone. You may be seated. Okay. All right, counsel. There's several legal issues that we still need to work with. It would be my intention that we will work through those issues now so that we don't have to deal with them in the morning. So, Officer Detwald, I'm going to release you for the day. You're not to discuss your testimony with anyone until you get back here tomorrow on this witness stand. Okay? All right. So we are adjourned for the day. Counsel, if you would come back to my conference room. Thank you.
The system's rigged, man, it's time to break free. Eyes wide open, gotta see